Good morning again, ladies and gentlemen of the jury, and I appreciate your efforts in being here timely on a fairly rough day. We conclude this case with my instructions. One thing for the record, counsel approach the bench, please. Members of the jury, you have heard the evidence and the arguments of counsel. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to follow these instructions and accept the law as I give it to you. You're not permitted to change the law nor apply your own conception of what you think the law should be. Now, a criminal case begins with the filing of an indictment. The indictment informs the defendant that she has been charged with a crime. You may not consider the fact that it was filed for any purpose. A plea of not guilty is a denial of the charge and puts at issue all of the essential elements charged in the indictment. Now, the defendant is presumed innocent unless her guilt is established beyond a reasonable doubt. The defendant must be acquitted of an offense unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged in the indictment. Now, reasonable doubt is present when the jurors, after you have carefully considered and compared all of the evidence, cannot say that you are firmly convinced of the truth of the charge. It is doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs, or depending on moral evidence, is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Now, you must determine the issues in this case based on the evidence. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, and any facts agreed to by counsel. You may consider both direct and circumstantial evidence. Direct and circumstantial evidence of our equal weight and probative value. You must decide from all of the direct and circumstantial evidence taken together whether the state has proven all the elements of the charged offense beyond a reasonable doubt. Direct evidence is a testimony given by a witness who has seen or heard the facts to which he or she testifies, and it includes exhibits admitted during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. Now, to infer or to make an inference is to reach a reasonable conclusion or deduction of fact which you may, but are not required, to make from other facts which you find have been established by direct evidence. You may infer a fact or facts only from other facts or circumstances that have been proven by a greater weight of the evidence. Whether an inference is made rests entirely with you. You have heard, and the court has admitted, State's Exhibit 74, which is the video-audio recorded statement of the defendant. While that statement was played in court, you were provided a transcript of that statement. That transcript is not evidence. Only the recorded statement is evidence. The transcript was merely an aid to facilitate listening. In the event you feel there was a discrepancy between what was actually said on the recorded statement and what the transcript said, you must rely upon the recorded statement. Now, the evidence does not include the indictment or any opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. The evidence does not include any statements or answers that were stricken by the court or which you are instructed to disregard. You must not speculate as to why the court sustained an objection to any question or what the answer to that question might have been, because these are questions of law and rest solely with the court. Now, the things you saw during the jury view are not evidence, but they may help you to understand the evidence. Now, you are the judges of the facts, the credibility of the witnesses, and the weight to give to the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You will apply the tests of truthfulness which you apply in your daily lives. These tests include the appearance of each witness upon the stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity he or she had to see, hear, or know the things concerning which he or she testified, his or her accuracy of memory, frankness or lack of it, intelligence, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. Use these tests and assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to determine what testimony to believe and what testimony not to believe. Testimony of one witness, if believed by you, is sufficient to prove any fact. Now, the testimony of the defendant is to be weighed by the same rules that apply to the other witnesses. Now, testimony has been admitted indicating that the defendant fled the state of Ohio and went to Brazil from March 2007 until January 2018, when she was returned to the United States. You are instructed that the defendant's flight from the United States to Brazil alone does not raise a presumption of guilt, but it may tend to indicate the defendant's consciousness or awareness of guilt. If you find that the facts do not support that the defendant fled the United States for Brazil from March 2007 until she was returned to the United States in January 2018, or if you find that some other motive prompted the defendant's conduct, or if you are unable to decide what the defendant's motivation was, then you should not consider this evidence for any purpose. However, if you find that the facts support that the defendant engaged in such conduct, and if you decide that the defendant was motivated by a consciousness or an awareness of guilt, you may, but are not required, to consider that evidence in deciding whether the defendant is guilty of the crime and specification charged. You alone will determine what weight, if any, to give to the evidence. Now, generally, a witness may not express an opinion. However, one who follows a profession, such as a Bureau of Criminal Investigation experts, Ohio State crime scene reconstructionist, and the forensic pathologist in this case may express opinions because of their education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. However, as with other witnesses, upon you alone rests the duty of deciding what weight to be given to the testimony of these experts. In determining what weight to give to the testimony of these experts, you may take into consideration their skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to the testimony. Now, a number of exhibits and the testimony relating to them have been introduced throughout the trial. You will decide what weight, if any, to the exhibits should you be given. You will decide what weight, if any, the exhibits should be given in the light of all the evidence. These exhibits may include, but are not limited to, documents, reports, video and audio exhibits, and other physical items. The numbering or lettering of the exhibits that you take to the jury room may not have been submitted by the party who produced it during the trial, or the court may not have admitted an exhibit because of a legal or procedural reason or ruling. Do not draw any inference because you do not have a particular exhibit. You will have in the jury room the verdict forms and all the exhibits received into evidence during the course of this trial. You will not be given any other exhibits during your deliberations. Now, the right of the court to try the defendant depends upon proof that the offense was committed in Trumbull County, Ohio. This is called venue. Venue is an essential element of both the offense and the specification charged in the indictment, and as with other elements, must be proven by the state beyond a reasonable doubt. Now, the defendant, Claudia C. Hoerig, is on trial in this case as a result of an indictment returned against her, charging her with count 1, aggravated murder with a firearm specification. Before you can find the defendant guilty regarding count 1, aggravated murder with a firearm specification, you must find beyond a reasonable doubt that on or about March 12, 2007, and in Trumbull County, Ohio, the defendant, Claudia C. Hoerig, did purposely and with prior calculation and design cause the death of another, to wit, Major Carl Hoerig, and at the time of the commission of the crime of aggravated murder, have a firearm on or about her person or under her control, and displayed the firearm, brandished the firearm, indicated she possessed the firearm, or used it to facilitate the offense. I will now define some terms for you. Purposely. Purpose is an essential element of the offense of aggravated murder. A person acts purposely when it is her specific intention to cause a certain result. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to cause the death of another, to wit, Major Carl Hoerig. Purpose is a decision of the mind to do an act with a conscious objective of producing a specific result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to herself unless she expresses it to others or indicates it by her conduct. How determined? The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the weapon used, and all the other facts and circumstances in evidence. The deadly weapon. You may infer a purpose or cause a purpose to cause the death of another, where the natural and probable consequences of the defendant's act is to produce death in the light of all the surrounding circumstances. Such circumstances include the weapon used and the capability to destroy life. If you find the defendant used a deadly weapon against another in a manner calculated to destroy life, the purpose to cause death may be, but is not required to be, inferred from the use of the weapon. Whether an inference is made rests entirely with you. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. Prior calculation and design means that the purpose to cause a death was reached by a definite process of reasoning in advance of the homicide, which process of reasoning must have included a mental plan involving studied consideration of the method and the means and the instrument with which to cause the death. To constitute prior calculation, there must have been sufficient time and opportunity for the planning of the act of homicide, and the circumstances surrounding the homicide must show a scheme designed to carry out the calculated decision to cause the death. No definite period of time must elapse, and no particular amount of consideration must be given, but acting on the spur of the moment or after momentary consideration of the purpose to cause death is not sufficient. Cause is an essential element of the offense of aggravated murder. Cause is an act which directly produces the death of another and without which it would not have occurred. You must consider the offense charged in the indictment. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of aggravated murder as charged in count 1 of the indictment, your verdict must be guilty. However, if you find the state failed to prove beyond a reasonable doubt all of the essential elements of the offense of aggravated murder, or if you are unable to agree upon a verdict of either guilty or not guilty of aggravated murder, you will continue your deliberations to decide whether the state has proved beyond a reasonable doubt all of the essential elements of the lesser included offense of murder. Now, if the evidence warrants it, you may find the defendant guilty of an offense lesser than that charged in the indictment. However, notwithstanding this right, it is your duty to accept the law as given to you by the court, and if the facts and the law warrant a conviction of the offense charged in the indictment, namely aggravated murder, then it is your duty to make such finding uninfluenced by your power to find a lesser offense. Now, this provision is not designed to relieve you from the performance of an unpleasant duty. It is included to prevent failure of justice if the evidence fails to prove the original charge but does justify a verdict for a lesser offense. Now, before you can find the defendant guilty of the lesser included offense of murder, you must find beyond a reasonable doubt that on or about March 12, 2007, and in Trumbull County, Ohio, the defendant did purposely cause the death of another, to wit, Major Carl Hoerig. Purposely has been previously defined. Cause has been previously defined. The lesser included of murder is distinguished from aggravated murder by the absence or failure to prior calculation and design. Now, if you find the state to prove beyond a reasonable doubt all of the essential elements of the lesser included offense of murder, your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt all of the essential elements of the lesser included offense of murder, then your verdict must be not guilty. You must consider the offense charged in the indictment and the lesser included offense. If you find the state proved beyond reasonable doubt all the essential elements of the offense of aggravated murder as charged in count 1 of the indictment or the lesser included offense of murder, your verdict must be guilty as to one of those offenses. However, if you find the state failed to prove beyond a reasonable doubt all the essential elements of the offense of aggravated murder or the lesser included offense of murder, or if you are all unable to agree upon a verdict of either guilty or not guilty to aggravated murder or the lesser included offense of murder, then you will consider the inferior offense of voluntary manslaughter. The defendant is asserting the inferior defense known as voluntary manslaughter. The defendant claims that at the time of the offense, she acted knowingly while under the influence of sudden passion or in a sudden fit of rage, either of which is brought on by serious provocation occasioned by Major Carl Hoerig that was reasonably sufficient to incite the defendant into using deadly force. Now, the defendant must establish such a defense by a preponderance of the evidence. A preponderance of the evidence is the greater weight of the evidence. That is, evidence that you believe because it outweighs or overbalances in your mind the evidence opposed to it. A preponderance means evidence that is more probable, more persuasive, or of greater probative weight. It is the quality of the evidence that must be weighed. Quality may or may not be identical with quantity or the greater number of witnesses. Now, in determining whether or not voluntary manslaughter has been proven by a preponderance of the evidence, you should consider all of the evidence bearing upon the offense regardless of who produced it. If the weight of the evidence is equally balanced, or if you are unable to determine which side of the affirmative defense has the preponderance, then the defendant has not established such affirmative defense. Now, if the defendant fails to establish the defense of voluntary manslaughter, the state still must prove to you beyond a reasonable doubt all the elements of the crime charged or any lesser included offense. Now, knowingly, a person acts knowingly regardless of her purpose when she is aware that her conduct will probably cause a certain result. A person has knowledge of circumstances when she is aware that such circumstances probably exist. Cause I've previously defined to you. Sudden fit of passion or fit of rage. Under the influence of a sudden passion or in a sudden fit of rage means that there is serious provocation occasioned by the victim, Major Carl Hoerig, that is reasonably sufficient to incite a person into using deadly force. It is an act done in the heat of blood without time to reflect or for passions to cool. Serious provocation. For provocation to be reasonably sufficient to bring a sudden passion or a sudden fit of rage, you must decide that the provocation was sufficient to arouse the passions of an ordinary person beyond the power of her control. When deciding whether the defendant was actually under the influence of sudden passion or a sudden fit of rage, you must consider the emotional and mental state of the defendant and the conditions and circumstances that surrounded her at the time of the act. Deadly force means any force that carries a substantial risk that it will probably result in the death of any person. Substantial risk means a strong possibility as contrasted with a remote or even significant possibility that a certain result may occur or that certain circumstances may exist. Now, if you find the state failed to prove beyond a reasonable doubt that the defendant purposely caused the death of Major Carl Hoerig with prior calculation and design, then you must find the defendant not guilty of aggravated murder as charged in the indictment. If you find the state failed to prove beyond a reasonable doubt that the defendant purposely caused the death of Major Carl Hoerig, then you must find the defendant not guilty of the lesser offense of murder. If you find the state proved beyond a reasonable doubt that the defendant purposely caused the death of Major Carl Hoerig, and you also find that the defendant failed to prove by a greater weight of the evidence that she knowingly acted while under the influence of sudden passion or a sudden fit of rage, either of which was brought on by serious provocation occasioned by the victim that was reasonably sufficient to incite the defendant into using deadly force, then you must find the defendant guilty of aggravated murder as charged in the indictment or the lesser included offense of murder. Now, if you find the state proved beyond a reasonable doubt that the defendant purposely caused the death of Major Carl Hoerig, but you also find that the defendant proved by a greater weight of the evidence that she acted knowingly while under the sudden influence of a sudden passion or a sudden fit of rage, either of which was brought on by serious provocation occasioned by the victim that was reasonably sufficient to incite the defendant into using deadly force, then you must find the defendant guilty of voluntary manslaughter. Now, if you find the defendant guilty of the offense of aggravated murder as charged in the indictment, or the lesser included offense of murder, or the inferior offense of voluntary manslaughter, Then you will separately consider the firearm specification. You must decide whether the state proved beyond a reasonable doubt that the defendant, at the time of the committing of the offense of aggravated murder as charged in the indictment, or the lesser included offense of murder, or the inferior offense of voluntary manslaughter, the defendant had a firearm on or about her person, under her control, displayed the firearm, brandished the firearm, indicated she possessed it, or used it to facilitate the offense. Firearm means any deadly weapon capable of expelling or propelling one or more projectiles by an action of an explosive or combustible propellant. Firearm includes an unloaded firearm and any firearm which is inoperable but which can be readily rendered operable. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specially adapted for the use as a weapon or possessed, carried, or used as a weapon. A deadly weapon is an instrument, device, or thing that has two characteristics. The first characteristic is that it is capable of inflicting or causing death. The second characteristic is that in the alternative, either the instrument, device, or thing was designed or specially adapted for the use as a weapon, such as a gun, a billy club, or brass knuckles, or it was possessed, carried, or used, in this case, as a weapon. These are questions of fact for you to determine. You may, but are not required to infer the possession and operability of a deadly weapon from the defendant's words or conduct. When deciding whether a firearm is capable of expelling or propelling one or more projectiles by an action of an explosive or combustible propellant, you may rely on the circumstantial evidence, including but not limited to statements, representations, and actions of the defendant. On or about her person or under her control means the deadly weapon was either carried on the defendant's person or was so near the defendant's person as to be conveniently accessible or within her immediate reach. Brandish means that to wave or exhibit in a menacing or challenging manner. Thus, if as to the firearm specification, you find the state proved beyond a reasonable doubt all the essential elements of that specification, your verdict must be guilty as to the specification. If as to the firearm specification, you find that the state failed to prove beyond reasonable doubt any one of the essential elements of the specification, then your verdict must be not guilty as to the specification. Now, you may not discuss or consider the subject of punishment. Your duty is confined to the determination of whether the defendant is guilty or not guilty of the charge. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, decide all disputed questions of fact, to apply the instructions of the court to your findings, and render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all of the evidence and make your findings with intelligence and impartiality and without bias, sympathy, or prejudice, so that both the state of Ohio and the defendant will feel that this case was fairly and impartially tried. Now, if during the course of this trial the court said or did anything that you consider an indication of the court's view of the facts, you are instructed to disregard it. Now, your initial conduct upon entering the jury room is a matter of importance. It is not wise to immediately express a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may then hesitate to change your position, even if you later decide you were wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case with your fellow jurors. Do not hesitate to change an opinion if you are convinced it is wrong. However, you should not surrender an honest opinion in order to be congenial or to reach a verdict solely based on the opinion of the other jurors. You will have with you in the jury room 6 verdict forms. I'll go through them now. First one, they're in the same order in which I instructed you, is for aggravated murder. We, the jury, duly impaneled, sworn and affirmed, find the defendant, Claudia Hoerig, and there's asterisks down below are the instructions. You insert the word guilty or the word not guilty in ink on that line of aggravated murder as charged in your first count of the indictment. There's a date line, 12 signature lines. Again, this is a criminal case. It must be a unanimous verdict by all 12 jurors. In addition to that, there's a finding of, if you find her guilty, then you address the firearm specification, which is attached to count 1, and the directions are you put the word did or did not at the time of committing aggravated murder have a firearm on or about her person under her control, brandished a firearm, indicated she possessed it or used it to facilitate the offense. Again, this is criminal trial, must be a unanimous 12. Again, if you drop to the lesser included offense because you found her not guilty of the aggravated murder or couldn't come to a verdict onto that, then you go to the lesser included. And again, guilty or not guilty of murder, 12 lines for signatures. The firearm specification goes to that too. So if you find her guilty of count 2, then you address the firearm specification as to count, or not count 2, the lesser included. And the third one is the finding for the inferior offense. If you haven't found her guilty of aggravated murder or murder, the inferior offense is she's guilty or not guilty of voluntary manslaughter. Again, 12 signature lines and a firearm specification as to that too. And again, the firearm specification is only addressed if you find her guilty of that particular charge. Now, from this time on, you will be in the charge of my bailiff. You will follow her instructions in every regard. If you desire to communicate with the court, you should do so in writing and only after careful consideration of the language used, so that the same does not unnecessarily disclose the status of your deliberations, and making sure that any inquiry is clear and unambiguous. These requests should be submitted in writing and signed by the foreman or forelady. During all breaks in your deliberations, you will follow the instructions of the bailiff, but do not discuss this case with her or even among yourselves during breaks. For example, if you're still deliberating at noon and we go for lunch, you can't deliberate in smaller groups than your 12. Now, the court will place in your possession the exhibits and the verdict forms, and the foreman or forelady will retain possession of these records, including the verdicts, and return them to the court. The foreman or forelady will see that your discussions are orderly and that each of you has an opportunity to discuss this case and cast your verdict. Otherwise, the authority of the foreman or forelady is the same as any other juror. Now, until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations and the nature of your verdict. Now, we had 4 alternates in this case, but I want to ask first if the original 12 members of the jury, are you ready and willing to proceed in deliberations? Seeing no indication in the contrary, then our four different alternates, Ms. Shelton, Mr. Harvey, Mr. Hulk, and Ms. DeGennaro, will not be necessary for you to serve in this case. When the jury is released to go into deliberations, you will be excused. I ask you to go back down to the pettit jury room and wait for additional instructions before you leave the court, though. But your service was just as important as everyone else. We were fortunate we did not have to call upon you. I noted you were attentive throughout this trial. All right. Anything else from counsel at this time? Anything from the state?
Just a brief typographical error that we can address from the jury.
You will have with you a copy of these instructions, and we'll make sure that we have any typos taken care of. Mr. Corneli, anything from the defense?
Just one error I noticed on a verdict form that we can correct.
All right, very well, we'll correct that. All right, your first duty upon entering the jury room, of course, is to choose one of your number to be a foreman or forelady, and again, that person should assist in your deliberations. I wish you luck in your deliberations. I turn you over to care of my bailiff at this time. Where is my bailiff?